So all this seems pretty complicated, Nadja. What advice would you give someone wanting to understand law of mediation in their country?
Well, I think it's useful to have a framework, and I've developed a type of matrix to help people plot the law, if you like,
Yeah.
In any particular jurisdiction.
Okay.
And if you look at it now up on the screen,
Yeah.
you'll see that down the left-hand column, you've got the regulatory content. So the 4 categories of mediation law: triggering laws, process laws, standards for mediators, and rights and obligations.
Yes.
That we talked about. And then across the top, you've got the different regulatory forms, the 4 different ones we talked about.
Okay.
So in the various empty boxes that you can see on that matrix, this is not about putting a tick or a cross, but rather for you to put in notes about what you find in that jurisdiction.
Yeah.
Let me give you an example.
Yeah.
So if I think about Hong Kong, and I'm looking at triggering laws, I know, for example, that there is a corporate pledge in Hong Kong, right? And so, for example, if I'm involved in a case with a particular corporation, I might want to investigate whether they've made that corporate mediation pledge and they're a member of that.
Okay.
Mediation clauses are popular, and there's Practice Direction 31. So I would put under private contract or marketplace the corporate pledge and mediation clauses, and then under institutional regulation, court practice direction, I would put Practice Direction 31.
Yeah.
Then when I go to process, I know that that's typically regulated in Hong Kong by the agreement to mediate, and also that there is a Hong Kong uniform standard recommended sort of set of guidelines or rules that you can incorporate into your agreement to mediate.
Yeah.
And there are also other organizational rules, but there's also a uniform one that's recommended by the Hong Kong Mediation Accreditation Association.
Okay.
So I would put in something in the first 2 boxes, in the private contract box and in the institutional regulation box.
Okay.
When it comes to standards, again using the example of Hong Kong, since 2003, Hong Kong has mediator standards regulated by one body, HKMAL, the Hong Kong Mediation Accreditation Association Limited, and so that would also go in the second box.
Yeah.
It's possible to use other mediators as well. So I'd also put a note in the first box under marketplace that if I don't want to use a Hong Kong law mediator, I'm allowed to as well.
Okay.
Right? So I'd make a note there. So you can see so far that there's not a lot. Everything's in the first 2 boxes, right? There's not a lot elsewhere. Well, that's because we haven't come to rights and obligations yet.
Right.
So if I look at, in the case of Hong Kong rights and obligations, in 2013, Hong Kong passed a mediation ordinance, a piece of legislation, which deliberately focused on rights and obligations only, specifically those relating to confidentiality.
Okay.
And there I would be writing the mediation ordinance in the legislation box under rights and obligations. But also in Hong Kong, depending on my case, there's a couple of other specific bits of legislation that might be relevant. For example, the estate agents legislation. So if I'm in a mediation with a real estate agent, I might also need to make note of that piece of legislation.
Okay.
The last thing, though, I want to say about this, there's also some jurisprudence, right? So there's also some case law interpreting triggering laws. So actually, I'd go back up to triggering and I'd identify some of the case law interpreting Practice Direction 31. And there's also some case law on confidentiality interpreting the mediation ordinance. Okay. So I'd note that there as well. But the other thing is, because as in just about every jurisdiction I know, mediation practice started before there was legislation about mediation, right? So people put everything into the agreements to mediate, right? They also put they put in stuff about a liability of mediators. They put in stuff about confidentiality. Sometimes they put in stuff about interpreting the mediated settlement agreement and enforceability. So when legislation came in, and Hong Kong's no exception here, people didn't all of a sudden stop putting these provisions in their agreement to mediate. They're still there as well.
Right.
So I'd also make a note of the agreements to mediate and the standard agreements to mediate that are available in Hong Kong and what they say. So insofar as there's a clash between what's in your agreement to mediate and the law prevails.
Of course.
But if there's a gap, that's when your agreement to mediate is relevant again.
Oh, okay.
Yeah. So by plotting all of this, it also makes me, for example, I had nothing in triggering, right? Nothing in that triggering line. I think, gosh, I'm missing something, right? I know I'd have to keep looking, all right? But it gives me a sense of, how this particular jurisdiction has balanced flexibility and certainty, right, in terms of its regulatory form. Helps me identify if there's any gaps. If I've got a situation I want a lot of certainty, I'm looking for some really clear, sort of legislative support, and I find the legislation doesn't deal with a lot of issues, or it only deals with some rights and obligations and not others, I can make a note of that. But then I also know that I need to make sure everything else is covered in my agreement to mediate, right? So it can help me, design insofar as there's no mandatory regulation. It can help me design my own regulation for my own mediation.
So this can not only help you make sense of what's going on in your particular country, but actually really help you preparing for a mediation. I know we're jumping ahead a little bit, and this might be covered in a future course, but where you are mediating between two parties from different jurisdictions in a neutral jurisdiction, for example.
Yeah, absolutely. Absolutely. It's incredibly useful there as well. Yeah.
This is great.